name is Shen. I'm a law professor. I work at the intersection of neuroscience and law, which is a really neat and new and emerging intersection. And we want to thank Teresa and Joel and AAAS for allowing us to do this innovative session. And thanks to you for being here, even at the end of the conference. 3 thank yous right at the start. 3 organizations that help make this possible. One is the Flashner Judicial Institute. Judge Bernard is the CEO, and we'll introduce her in a second. The Center for Law, Brain, and Behavior at Mass General Hospital, and Dr. Kinscherff, sitting over there, we'll meet in a second, is the executive director. And then the Dana Foundation Neurotech Justice Accelerator, NJAM at Mass General Brigham. So thanks to all 3 of those groups. Today's program is meant to give you an insider's view about how science enters the courtroom. At the outset, I want to stress that you are going to see one particular type of science, the science of emerging adulthood, in one particular legal context. Our context is criminal sentencing, and in one state, the state law of Massachusetts. Each particular science, each legal context, each jurisdiction, the stuff will be a little bit different, but we think that there are going to be some themes from today that will be resonant across just about every context. One of those themes is the science, whatever it might be, today the science of emerging adulthood, sufficiently well developed to be put in the courtroom? That's the validity of the science. And second, a theme that will come up today is how can group average science about groups apply to a particular individual? And that's going to be center stage today as well. So with those concepts in mind, let me introduce you to our all-star cast. And to the case. So the case today is fictional. You're going to learn about a young man named Oliver Twist, 20 years old, and you can listen carefully to find out about his story and then about what might happen to him in the criminal system. A couple of just words of context, so you may not be familiar with this. So in the United States, we have a bifurcated system. There's the guilt phase, right? You know that from the movies, guilty or not guilty. And then today, what you'll see is the sentencing phase. What happens after a guilty verdict, and how might science impact that sentencing? The question about Mr. Twist is what sentence he'll receive. Judges, and you'll hear from Judge Bernard, have a lot of discretion, though not entire discretion, but a lot of discretion in how they sentence, and they've always taken many factors into account. Today we'll ask how, if at all, should they add neuroscience to the factors that they use when sentencing. We chose to focus on this science of emerging adulthood because Massachusetts last year had a landmark decision from the Supreme Judicial Court that raised the age at which the criminal system could sentence someone to life without parole. It used to be that juvenile, you had to be under 18, but in the case Commonwealth v. Mattis, that largely based on neuroscience evidence, and Dr. Kinscherff was an expert, the court raised the age, including 18, 19, and 20-year-olds. So in post-Mattis case law, like we'll see today, we're going to see what other kinds of ways science might intersect and persuade judges. We couldn't have a better group to lead you through this exercise. Presiding, and I'll turn it over to her in just a moment, will be the Honorable Julie J. Bernard. Judge Bernard was appointed to the bench here in Massachusetts in 2002, served as an Associate Justice of the Massachusetts District Court, and just retired here at the end of 2024. But she is not really retired. She has just taken on many new roles, including she is the CEO of the Flashner Judicial Institute, which leads education and training for Massachusetts judges. While on the bench, she was an Access to Justice Commissioner, chair of the District Court Alternative Dispute Resolution Committee, and she's worked with us extensively on our Neurolaw program. And thanks, Judge Bernard, for leading our work today. Representing the Commonwealth of Massachusetts will be Attorney Alexandra G. Gordon. Attorney Gordon is an assistant district attorney in the Suffolk County District Attorney's Office, working out of Dorchester District Court. Thanks for being here, Attorney Gordon. Representing the defendant will be Attorney Ryan Schiff. Attorney Schiff is an experienced appellate, criminal, and civil litigator. He's briefed and argued a wide range of both criminal and civil cases for the Massachusetts Appeals Courts, Massachusetts Supreme Judicial Court, U.S. Court of Appeals for the First Circuit. Extensive trial experience, first-degree murder cases, federal racketeering, trespassing, direct possession cases. Most relevant today, remember that landmark case that I mentioned? It was Attorney Schiff who was the lead attorney there. So happy that you're here. Our expert for the day will be forensic psychologist Dr. Robert Kinscherff. Dr. Kinscherff, I think, is the nation's leading expert at the intersection of adolescent and emerging adult science and criminal law, testified in state and federal cases across the country. Also, as I mentioned, the executive director of the MGH Center for Law-Abiding Behavior, and was the associate vice president for community engagement and professor in the doctoral clinical psychology program at William James College. And as I mentioned, it was his testimony that was key to this landmark case last year in Mattis. Now, one note, again, contextual on the experts. Because of time, we have just one expert. But in Mattis, and in most cases, you wouldn't have just one expert. And in particular, what you might have, and this happened in Mattis, is a basic neuroscientist, in that case it was Adriana Galvan from UCLA, and then a clinician who could bridge that group to individual inference. What we've asked Dr. Kinscherff to do today is almost play two roles in the interest of time. All right, the last couple of notes. If you're a lawyer in the room, yes, you're going to notice that we're not doing all of the details. For instance, sometimes a judge might hold an evidentiary hearing in a different context to see whether a piece of evidence can be admitted. That's not what we're doing today. Also, in many contexts, an expert may use an exhibit, like an image. In the interest of time and streamline, we didn't do that today either. Finally, last point, I want to stress that courtroom adjudication is not the only way that science enters the law. And in particular, I want to commend Suffolk County District Attorney Kevin Hayden, who is working with the Center for Law-Abiding Behavior and Mass General Hospital on an emerging adult program for young adults, 18 through 25, so that rather than end up in a courtroom, there is an alternative path that is a path that is really influenced and informed by the science of emerging adulthood. But again, that's another program. So today, we are in a courtroom, and that means that we need a judge, and I want to please join me in welcoming Judge Bernard. It is yours.
Thank you all. Can you hear me?
Yes.
Okay, thank you. Thank you, Dr. Shen, for that generous introduction. Today, now more than ever, it's important that we have these discussions about the intersection of science and law. At Flashner, we committed to educating judges and court personnel about this important intersection. And I'm grateful for the opportunity to be here today. I want to tell you, as Dr. Shen has told you, that emerging adult cases are a new area that the courts are talking about. And the Mattis decision was a landmark decision, and we are very grateful to be able to discuss it today. It was a landmark decision for Massachusetts, but I feel that science was talking about this area of neuroscience for many years. And I also think that the judiciary was talking about it for many years. But it had not been codified, or it had not been, there was never a judicial decision that talked about it. I was a specialty court judge. I worked in drug courts, mental health courts, and there was always a discussion about the brain or neuroscience of how a brain of a young adult between the ages of 18 and 25 was different. And they had different impulses and interactions. And that was a discussion that was had for many, many years in the court system. But Mattis has now highlighted that it is the law that a person of that age cannot be sentenced to life without parole. So with that said, we are going to start with the case of Oliver Twist. And as Dr. Shen has indicated, Oliver Twist has been convicted by a jury of his peers of voluntary manslaughter. And under Massachusetts law, he's been convicted beyond a reasonable doubt. The charge of voluntary manslaughter under Massachusetts case law is defined as intentional homicide without malice aforethought in the heat of passion as a result of adequate provocation. The maximum penalty under Massachusetts law is 20 years in state prison. Now, I'm going to talk to you more about the sentencing considerations that I will have in making my sentencing decision at the end of the presentations by counsel. I am now going to call Attorney Schiff and Attorney ADA Gordon to their positions to make their arguments in their examination of the witness. Attorney Schiff.
Thank you, Your Honor. Ryan Schiff on behalf of Oliver Twist. So as you know, Mr. Twist has pled guilty to manslaughter, and we're now here for sentencing. I am going to be asking for a sentence of 7 to 10 years. And before I make my argument, I would, with your Honor's permission, like to call an expert witness on the issue of his culpability and what a reasonable sentence is.
You may call your witness.
I would like to call Dr. Robert Kinscherff.
Good afternoon, Your Honor.
Good afternoon. Do you raise your right hand? Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You may be seated. You may begin.
Thank you, Your Honor. Good afternoon, Dr. Kinscherff. As you know, I'm Ryan Schiff and I represent Oliver Twist. And I may have some questions for you today. Can we start just by having you state your name, spelling your last name for the record?
Robert Kinscherff, K-I-N-S-C-H-E-R-F-F.
Are you currently employed, Dr. Kinscherff?
I am.
Where are you employed?
I'm currently employed as the Executive Director for the Center for Law, Brain and Behavior at Massachusetts General Hospital. I also continue to teach as a professor in the doctoral clinical psychology program at William James College.
How long have you been a professor?
Oh, well, the school just went to academic rank about 5 years ago, so I would say about 5 years.
Could you briefly describe your educational background?
I received my bachelor's degree from the University of California at Berkeley in 1977. I received my master's in philosophy at the University of Chicago in 1980. In 1986, I received my doctoral degree in clinical psychology from the City University of New York. In 1992, I graduated from Harvard Law School.
After your doctoral training in psychology, did you do any postdoc training?
I did postdoctoral training at the Boston Juvenile Court Clinic. I also did some early career professional training in threat assessment with a program that has been developed. I'm not sure what's still going on, that was some time ago, at the Central Intelligence Agency.
Do you have any peer-reviewed scientific publications?
I do.
Can you describe those, please?
Most of my scientific publications are in the area of violent offenders with or without mental disorders, both adults and juveniles. I've also done work in the research on post-traumatic stress disorder and exposures to adversity in childhood.
Approximately how many peer-reviewed articles have you published?
About 70 at this point.
Have you conducted any kind of trainings for judges or other decision makers?
Yes, I have.
On what topics?
For both state and federal judges in Massachusetts and elsewhere, I have trained on violence risk assessment, the management of violent offenders, adolescent and young adult neurodevelopment, and the role of mental illness in criminal conduct.
And when have you conducted those trainings?
I started conducting those trainings probably 1985, 1986, and have done at least one a year since that time. Often 3 or 4 times a year at different jurisdictions, federal and state.
After the Supreme Judicial Court's decision, Diachenko, did you conduct any trainings?
I did. After the Diachenko decision, I was invited by the Supreme Judicial Court to give a briefing on the neuroscience of adolescence in anticipation of the Supreme Judicial Court taking up the Supreme Court's decision in Miller and applying it to the state legal system through a case that was issued in 2013 called Diachenko.
ADA Gordon, is there any objection to Dr. Kinscherff as an expert witness in this case? No objection, Your Honor. All right, you may proceed with the substantive question.
Thank you. What kind of psychologist are you?
I am trained as a clinical psychologist and as a developmental psychologist. After my training in clinical psychology, I went on to develop experience and expertise in forensic psychology.
What is forensic psychology?
Forensic psychology is a field in which psychological science is applied to cases that will be reviewed by legal decision makers sometimes judges, sometimes parole boards, sometimes correctional authorities, and others. The goal is to generate forensically defensible, reliable science that the decision makers can use.
What is developmental psychology?
Developmental psychology is the field in which we look at the unfolding of children from pre-birth through old age and death. It's a lifespan development perspective. My particular areas have been in childhood, adolescence, and early young adulthood. It's an effort to understand the developmental unfolding at biological levels, psychological levels, social levels, and the like as someone matures.
How does neuroscience fit into that study of developmental psychology?
The neuroscience came relatively a short time ago as we developed techniques, so how it fits in is a matter still of some discourse, but I think the consensus would be that developmental neuroscience has been extremely helpful in understanding what we have seen developmentally and behaviorally. That is to say, to the extent to which the mind is instantiated in the brain, understanding how the brain develops is important in understanding the manifestations of that brain activity in behavior, cognition, and the like.
Can you explain what an MRI machine is?
An MRI machine is an image machine that essentially will give you images of the structure of a human brain.
How are MRI machines used in neuroscience?
Used in research in neuroscience in order to try and at least understand the gross structures of the human brain and to ascertain if there are things that may be helpful in clinical medicine as well.
Can you explain the difference between MRI machines used to study the anatomy of the brain versus functional MRI imaging?
Yes, an MRI essentially gives you a picture of the structure of the brain, and they can cut it very finely so you can see structures through the brain itself. fMRI is different because it allows you to see in real time the functioning of certain parts of the brain as the individual who's being scanned is asked to do various tasks.
Can you briefly explain what developmental neuroscientists have found about how young people's brain develop through adolescence?
Yes, briefly, with the onset of puberty, the brain begins to go through a process of substantial change of its structure and its function. It develops from back to front, which means functionally that parts of the brain that are responsible for biological regulation and the like at a pre-conscious level, like your heartbeat, your temperature, your balance, that sort of thing, develops. Then the midbrain, and then finally the cortex, and importantly the prefrontal cortex comes online. So, and that occurs in the early 20s into the early 30s.
Are there implications for understanding behavior from that science?
Yes.
What are those implications?
There are a number of implications. One is that because the adolescent's brain is continuing to develop more rapidly below the prefrontal cortex, you will see challenges, especially as their endocrine system becomes active and they are balancing hormone changes in their hormones and so forth. You may see things like relative difficulties in emotional regulation. There are also parts of the brain that have reward systems, especially, but not only dopamine reward systems, that are more active and sensitive during adolescence than they will be later in life. There's a particular part of the brain, for example, that in the presence of peers activates reward centers in a way that that brain center will not do when they're in their mid-20s, early 30s, and so forth. That may help us explain things like the relative sensitivity to peer influences that they have, the challenges that they sometimes have in emotionally arousing situations, in making good decisions, and help us understand their, for want of a better word, adolescent moodiness and reactivity, as the control centers, top-down controls, are not yet fully mature. As one neuroscientist explained it to me, it's normative during adolescence to have a phase of development in which you have the mighty midbrain of a Mercedes sports coupe, but the brakes of a Honda Fit.
Beyond neuroscience, have developmental psychologists also in other ways studied adolescent behavior and risk-taking?
Yes.
What have they found?
They found that adolescents are essentially wired for a higher degree of novelty and sensation seeking, at the same time that their frontal lobe is not yet fully equipped to engage in the kinds of option detection, weighing of potential consequences and the likelihood of those consequences, and to make decisions on the basis of what we would think of as a more fully informed decision-making process. This is particularly the case in circumstances of what the cognitive psychologists call hot cognition, a period of circumstances in which an individual is highly emotionally aroused. They believe that they have to act immediately or within a very, very short time frame. Their decisions are more limited than they might actually be in decisions that an adult might make, and they're more prone to reactivity in that kind of hot cognition. While most adolescents are about as good as most adults by age 16 in cold cognition, when they're calmer, they can think things through, they may have somebody to talk with them about the decisions they're going to make, like medical informed consent. This vulnerability to hot cognition persists until the early 20s.
Are you familiar with the age crime curve?
I am.
What is that?
The age crime curve, which we've known about in criminology and sociology since at least the 1920s, is based on the observation that with the onset of puberty especially, there is an increase of misconduct of all kinds. We think that reflects the novelty seeking, the stimulation seeking, and so forth, risk taking. And that continues to increase through mid-adolescence and to late adolescence. But by about 23, 24, 25, most persons will desist from serious misconduct and criminal misconduct. They'll self-desist because of the completion of most of their brain development and also entry into adult roles.
Is there any conflict between what we would have expected to see from the neuroscience and developmental psychology and what we actually see in the real world with the age crime curve?
No, this convergent data has actually been extremely important to see that we are now beginning to understand the neural mechanisms that underlie the behaviors that people have seen in adolescence for years and years. As the Supreme Court opined in the Roper case, every parent can tell you that children are different.
How about capacity for change? Have scientists studied the capacity of adolescents to change and rehabilitate after they've committed offenses?
Yes.
What have they found?
The basic finding is that the behaviors, the attitudes, the values, beliefs of adolescents as they enter early young adulthood are really quite malleable, and that persons who commit serious offenses in adolescence are not beyond rehabilitation. That's also been mentioned in the line of Supreme Court cases, that they have a greater potential for rehabilitation, and the science would bear that out.
Do we have an understanding, or is there a scientific understanding of why adolescents have this capacity for change?
We think there are a number of contributors. One is continued brain development into the early to mid-20s and beyond. There are a variety of social factors as they move out of adolescence and into the responsibilities and roles of adulthood. Their prefrontal cortex becomes more active, if you will. It becomes more of a figure in the decision-making processes. They can inhibit impulses longer. They can project alternative futures with greater accuracy. They can anticipate consequences that they previously may not have even considered in the moment when they were younger. In fact, this is such a robust finding that The Supreme Court also observed in Roper in 2005 that the heinousness of a crime committed in adolescence is not a reliable predictor of potential for future rehabilitation.
Now, Mr. Twist was 20 years old. These scientific findings extend to people in that age group?
Yes, they do. Particularly the vulnerability to rash or reckless actions and poor decision-making under conditions of hot cognition. Or as one of my neuroscientist colleagues pointed out to me, that's why you can have the same young person with the same brain who's on Dean's List at the physics department where they're at university and then do just some wildly stupid things while on spring break.
Are you aware that Mr. Twist has pled guilty to manslaughter?
Yes.
Have you read the grand jury minutes as well as the relevant police reports in this case?
Yes.
Do you have an opinion to a reasonable degree of certainty about the role adolescents could have played in the commission of his crime?
Yes.
And can you explain that to the court?
I believe that there is solid evidence from a scientific point of view that Mr. Twist, at the time of the commission of his offense, was in a state of hot cognition. His capacities for short-term decision-making were impaired, and to the extent to which that youthful characteristic played a role in the circumstances leading to the death of his victim, it would be consistent with what the science tells us about hot cognition even in late adolescence.
Did you conduct an evaluation of Mr. Twist?
I did.
How long did you meet with him?
I met with him, including the assessment tools that I used, for 6 hours.
What kind of assessment tools did you use? What kind of testing did you do?
I give a general clinical screen called the Personality Assessment Inventory that helps me look for diagnosable conditions, gives me a read on somebody's vulnerability to impulsivity, other things that may be useful for understanding him for planning rehabilitation strategies. I also give a level of service case management inventory. This is a risk assessment tool that focuses on recidivism for criminal acts specifically, not murder specifically, but any criminal act. In his particular case, I also gave him an inventory. It's the inventory of offender risks, needs, and strengths. That compares him to other persons who have been convicted of crime, so we get a sense of how he compares to a criminal population on static risk factors, meaning things that have happened in his history that he can't change, like his age of first arrest, things that are changeable, so-called dynamic factors, things like if he were to be a serious substance abuser, that can be changed through intervention and treatment, and finally a profile of his protective factors or resiliency.
Now, can you briefly, perhaps more briefly than you would if we were down the street at the Suffolk Superior Court, explain what the results of that testing were?
Yes, Mr. Twist, and consistent with the testing, I believe suffers from a substance use disorder, particularly alcohol, cannabis, although he's a polysubstance user and has included psychedelic substances and methamphetamine. I believe he has some features of post-traumatic stress disorder, although not enough to meet the full criteria. We would put him in a different box, developmental trauma or complex trauma. Other than that, he had no other diagnosable conditions. The testing also profiled him, or the risk assessment tools also profiled him as being at low to very low risk of criminal recidivism.
Does he have any specific characteristics that you think are significant to understanding his capacity for rehabilitation and change?
I think if his substance use disorder was effectively treated, there are no obstacles for his capacity for social learning, which is really what we're looking for in rehabilitation. He has some obstacles in educational attainment. He has a history of difficulty learning to read. He also did not have any special education to help remediate that. My impression of him is that with a proper educational strategy, he would be capable of at least high school, and even some college attainment.
Attorney Schiff, we need to move on to cross-examination. Can you wrap this up?
I have one more question, Your Honor. Do you, Dr. Kinscherff, have an opinion to a reasonable degree of scientific certainty about his prognosis for rehabilitation over the next 7 to 10 years?
I think his prognosis for rehabilitation is quite good, particularly as he does not have a long history of juvenile arrest. There were very specific social circumstances that helped drive his involvement in this crime. But I, from a correctional point of view, would see him as a relatively straightforward inmate with clear, meetable needs.
I have no further questions at this point.
ADA Gordon, you may cross-examine the witness.
Thank you, Your Honor. Good afternoon.
Good afternoon.
Now, doctor, outside of your evaluation with Mr. Twist, have you met him previously?
No.
And about how long was that evaluation?
I'm sorry.
About how long was that evaluation?
It was about 6 hours.
Now, at this point, Mr. Twist had already pled guilty to involuntary manslaughter. Is that correct?
That's my understanding, yes.
Now, during this evaluation, did you have an opportunity to study Mr. Twist's brain?
No.
Can you hear me okay?
Yes.
And that, fair to say, that means you did not conduct an MRI on Mr. Twist's brain?
That's correct.
Or a functional MRI, as you stated, correct?
Correct.
Now, in your peer review studies or with other patients, are MRIs an important factor in coming to a conclusion as to whether any of the Miller factors would play a part in someone's sentencing?
It can be, especially if you have some basis to believe there may be some significant brain pathology. But typically these are evaluations that are not conducted with an fMRI or an MRI.
And you briefly mentioned this, but an fMRI sees the brain in real time, correct?
Yes.
And an MRI, in what setting would that happen?
That is to look at the structure of whatever is being scanned. So in brain MRI, the basic anatomical structures of the brain. If they think you have a broken ankle, it would be the bone structure and so forth of that particular limb.
And when you do conduct an MRI on one of your patients, what could an MRI tell you that would be relevant for sentencing purposes?
Well, I first need to tell you that I wouldn't conduct the MRIs myself. I'm not trained to do an fMRI or an MRI. But what I would expect to see or be told about is any sort of lesion or tumor or other pathology that might be structurally detectable in the brain. The presence of an anomaly of brain structure, however, is not itself indicative of relevant behavioral pathology. So we would have to look specifically at where and what kind of pathology we might have.
And you had stated there is solid evidence regarding Mr. Post as to why he has the opportunity to rehabilitate, why his youthfulness did play a large role in him murdering this victim, correct?
Yes, that was my opinion.
And what is that solid evidence?
I'm sorry?
What was that solid evidence?
The solid evidence included the police reports, his Miranda transcripts, and what was elucidated at trial. He did make a decision in colder cognition circumstances to participate as a lookout with his 17-year-old co-defendant. They imagined that the homeowner would not be in the house, that the 17-year-old would go in, he would find what they believed to be a large amount of money in the home. Unfortunately, when the 17-year-old entered the house, the homeowner was there. Mr. Twist heard shouting, yelling. He ran to the house in order to see what was going on and to help his co-defendant. As he entered the screen door, he observed the homeowner backing his co-defendant up with a shotgun. He had come in at the side and had tackled the homeowner. The homeowner continued to struggle. would not give up the weapon, and the two of them began to beat him repeatedly, kick him in the head, and the like. My understanding from that description and his account of the day, of the events of that day, they were consistent with each other, and he described himself as he went in as freaking out, really scared, that somebody was going to get seriously hurt, his co-defendant was going to be shot. He felt as though he needed to act immediately. There was, in his mind, no reasonable basis to believe that he could talk the homeowner into putting down the weapon or defusing the situation. And in that moment of decision-making, reactive, frightened, he tackled the victim, and they commenced to harm him enough that he eventually died.
So it sounds as though Mr. Twist and his co-defendant made a plan, correct?
They did make a plan, yes.
They made a plan to commit this crime, correct?
Yes.
They executed that plan, correct?
They did not execute the plan that they had planned. They executed a plan, but unfortunately, what was assumed in their plan, that the homeowner would not be there, turned out not to be the case.
Once they learned that the homeowner was present, they continued with their plan. And in fact, it escalated, correct?
Yes.
To the point where the victim lost their life, correct?
Sorry?
To the point where the victim lost their life, correct?
Yes.
And that was at the hands of Mr. Twist, correct?
I'm sorry, I'm having a little,
That was at the hands of Mr. Twist, correct?
once again, you have to be closer to the microphone.
That was at the hands of Mr. Twist, correct?
Yes, he and his co-defendant.
Now, he ended up speaking to the police, correct?
Yes.
And he told them what happened.
Yes.
Fair to say he understood that he was speaking to the police, correct?
Yes.
And he knew there were consequences coming his way once he told the police what happened, correct?
Actually, what he told me was that he did not understand what the potential consequences were, that he didn't understand that in Massachusetts law, once you agree to participate in a felony, then you are legally responsible for the consequences of that participation in a felony, even if it was unplanned. So he believed that he was telling the police that he had agreed to be a lookout. He did not appreciate that, in fact, by telling them that information, he was implicating himself in something that could lead to a much more serious charge.
But he knew there was some sort of consequences for what he did.
Yes, he knew he was in trouble.
Now, Doctor, based on your peer review studies, you cannot conclude that any of those factors were present during the commission of this crime, correct?
I can conclude that if that account is credible, it would be consistent with what we know about the science of adolescent decision-making in odd cognition circumstances.
But you haven't reviewed Mr. Twist's brain, correct?
I have not reviewed Mr. Twist's brain.
So we're talking generalizations, fair to say?
No, we're talking about the application of what the science would tell us in an individual case. That's not unlike what any physician does when they take information, for example, about cancer from the research on oncology, that they have to then apply it to the individual patient who may have cancer in front of them. You draw inferences from the research and you look to see whether or not they align with the data you have in front of you or the facts you have in front of you.
But every kid is different, right?
That's true.
And simply because Mr. Twist, I believe you diagnosed him with a substance use disorder, correct?
Yes.
Fair to say other people with substance abuse disorders do not commit this type of crime?
That would be fair to say.
Fair to say someone with a, I believe you also diagnosed him with PTSD, correct?
I did diagnose him with PTSD.
Fair to say someone with PTSD doesn't always commit this type of crime as well, right?
That's true. However, people who do have PTSD, particularly in high stress circumstances, are more likely to respond reactively than more thoughtfully, particularly if the trigger, if you will, if the event in front of them is highly stressful and unanticipated.
But it doesn't always mean someone's going to break into an individual's house and kill them, correct?
That's correct.
And Mr. Twist is 20 years old, right?
That's correct.
And there are other 20-year-olds that don't commit this crime, correct?
That's correct.
And there are other 20-year-olds who have dealt with similar situations as Mr. Twist, such as losing a parent at a young age, that do not commit this crime, correct?
That'd be correct.
And going back, you've never, Mr. Twist is not a patient of yours, correct?
He's not a patient of mine, no.
And you've never treated him specifically, correct?
I've not been a treatment provider for him.
Your Honor, I don't have any more questions.
Thank you. Any redirect, Attorney Schiff?
A few questions, Your Honor. Thank you.
Dr. Kinscherff, in conducting your evaluation of Mr. Twist, did you look at the general science of adolescent development?
Yes.
Did you also look at the facts of this particular case?
Yes, in the same way that somebody practicing clinical medicine would rely on the general science of their specialty of medicine and then try to apply it to the individual case of a patient.
And did you also look at Mr. Twist's individual characteristics as a person?
Yes, I did.
Did you take all of those things into account, the general science, the facts of his crime, as well as his individual characteristics when forming your opinion?
Yes, I did.
Can you explain the difference between hot cognition and cold cognition once again, so I can understand that distinction?
Sure. Cold cognition occurs when an individual is asked to make a decision at a time when they are not highly aroused emotionally, physically, when they believe that they have some time to actually consider information, maybe even to get input from other people, and where people can help them through a deliberative process. So for example, most adolescents are about as good as most adults by age 16 or 17 as being competent to stand trial. But they are typically in a room with their attorney, they're talking about it, the attorney can say, you don't have that quite right, or here's another option you may wish to consider. Same thing is true with medical informed consent. Most adolescents by about 16, 17 make about as good a decision-making process as most adults would under the same circumstances. Where adolescents remain more vulnerable than adults, partly because of the delayed maturation of the frontal lobe and the sort of hyper activity, if you will, during that developmental phase of the midbrain, the amygdala, is circumstances of hot cognition. Hot cognition occurs when you are highly emotionally aroused, often physically aroused as well, especially in fear or anger. You believe you have to make a decision almost immediately or immediately. You don't have the opportunity or think you don't have the opportunity to explore options, discuss it with other people, and so you tend to respond in a more emotionally driven and reactive way in order to achieve a short-term goal. In this particular case, to stop the advance on his co-defendant of the victim with the weapon.
How quickly can somebody go from a state of calm, cold cognition to a state of hot cognition?
Almost immediately. When the situation arises, let's take a threat situation, people tend to react very, very quickly if there is enough of a perceived threat. A very, very simple example of that is somebody who may be driving on the freeway and suddenly a car veers. They don't sit down and figure out the angles of escape. They immediately make the best decision they can in an immediate moment, and hopefully it's correct and the two cars don't crash. And many of them, after they've just about been hit at 70 miles an hour by a car, their heart is going, their adrenaline is driving their autonomic nervous system.
You were asked some questions on cross-examination about the fact that there was no MRI conducted on Mr. Twist. Are MRIs typically ordered for these kinds of forensic examinations?
No.
Do you have an opinion about whether an MRI was needed to form an opinion about Mr. Twist's capacity for change in his risk profile?
I had no information to believe that he was suffering from any pathological brain process that would have contributed in a significant way to his situation. So for example, if he was somebody who had come with a history of concussion with resulting frontal lobe injury, I would have asked for an MRI or at least a neurology consult to see if that was necessary. But I had no information that he had sustained that sort of injury or had any other pathological process that would have been implicated.
Beyond that kind of neurological pathology, is there any way that an MRI can be used to say that one particular adolescent is more or less neurologically developed than another?
On group data, that tends to statistically sort of wash out, but what it is good for is looking to see whether or not in the individual case there may be some sort of gross pathology that contributed to it. But there's huge scatter, and there are people who have brain functional anomalies that don't show up in disordered thinking or behavior. So we have to be careful about drawing the lines between the two. And in this particular case, I didn't see that there was any basis to go forward with an fMRI or an MRI.
Thank you. I have no further questions.
Thank you. Any further evidence from the defense in support of your sentencing recommendation?
No, I do not, for the purpose of this particular demonstration.
Okay, thank you. Commonwealth, what is your sentencing recommendation for Mr. Twist?
Your Honor, the Commonwealth would be recommending a 15 to 20-year sentence in this matter. That is largely in part due to the set of facts before Your Honor. Understanding Mr. Twist's young age of 20 years old, an individual lost their life at the hands of Mr. Twist, and that would be the recommendation from the Commonwealth. That would, Commonwealth's perspective is appropriate.
Do you have any information to provide to the court from the victim or the victim's family at the sentencing hearing?
I do, yes.
You do? What
I
information?
believe there is a victim impact statement from the victim's family.
Okay, a written statement?
Yes.
You'd like to provide? Okay, thank you. And that concludes this sentencing hearing. All right. For the purposes of this demonstration, that concludes the testimony portion of it. I will tell you that every sentencing is different. And as Dr. Shen has indicated, every sentencing, a judge has a lot of discretion and latitude to determine an appropriate and individualized sentence, which is legal and within the statutory framework. And as I indicated at the beginning of this exercise, the maximum penalty for voluntary manslaughter is a 20-year prison sentence within a state prison sentence. Now, in making an assessment of how to sentence someone, as a judge, I have a responsibility to look at the defendant's character, behavior, background, the nature and circumstances of the offense, any aggravating or mitigating factors, and part of that is, yes, the science of it. And it is important to consider the facts that have been presented to me. I can tell you in this particular case, in a case like this, which is important, public safety is always a consideration. I consider Mr. Twist's prior criminal history, if there was one. We don't have any facts about his prior criminal history. We do know about his social history, and which is somewhat limited. He has a very poor family history background, living on his own, hand to mouth. We have a victim impact statement for the individual that is deceased. And the Commonwealth, the victim has a statutory right to make an impact statement. If the victim was not present and they waived that right, I would accept the written statement from the victim. But in a case as serious as this one, if the victim wanted to be present, I would render my sentence on a day when the victim could be present in the courtroom to make a statement to the court. On a case as serious as this one, I actually would take a recess, review any written documentation, because I think in a case like this, I would have written documentation to review. And I would look at that written documentation, look at Mr. Twist's history of, his background and experience, because I have found, and I take every sentencing decision seriously, but in a case like this is a serious one. Now, in the district court, we didn't handle, manslaughter cases, but as a practitioner, I did. But even in the district court, even the smallest decisions, and I was a mentor for many years, I tell people, every decision you make impacts an individual, a family, a community, public safety. You have to take it seriously. So I would think about the decision I was making before I'd make it, and I'd probably recess to my chambers, review all of the paperwork. If the victim chose to be president of the Commonwealth, indicated that, I'd probably set a day to render my decision, because you never rush justice. That is never a good thing. And I can tell you that over my 22 years as a sitting judge, I found that incarceration does not benefit anyone. I am a big proponent of restorative justice practices. We don't have a lot of them in the Commonwealth, but there are more and an increasing discussion and acceptance of those practices. Particularly in the area of emerging adult population, and someone like Mr. Twist's background, I think a 7 to 10 year sentence would be more appropriate, because sending someone to jail for 15 to 20 years does not do anything but, I believe, create a criminal. I spent some time in Alabama this past fall at a conference, and I had the opportunity to talk with justice-involved individuals, people that had actually, I sat at a table with Contrell Jackson, Miller versus Alabama, who was exonerated by Brian Stevenson. And you know, when you sit with people that have had that experience, he was part of, you realize that incarceration sometimes does not benefit people in the long run, particularly young people that haven't had the opportunity to develop as people, as persons. So I think science is so important. At Flashner, Dr. Shen, Dr. Kinscherff know that we are committed to expanding the knowledge that judges, I think it's integral to being an excellent judge, and that's what Flashner is committed to, excellence in judging, that you must have these kinds of conversations and learning lessons to know and understand the science behind this type of work, to know what's coming into your courtroom. When we open our courtroom doors, all of the problems of the world come into our courtroom. And we need to know what is going on with the people that we see before us. And I think that it's integral to understand the science of what's going on in the world and what's going on with people in the communities that we are serving. So that's how I would make my sentencing assessment. I don't know if anybody has any questions of any of these people. I mean, Dr. Kinscherff, I mean, he is a rock star here, and they have the opportunity, and even Attorney Schiff and Gordon, they did a phenomenal job. But does anybody have any questions? I'm just curious about the audience. Are there law students, they're doctors, they're scientists? Anybody any questions about what you've seen, about the process? Sure.
Hi, my name is Miles. I'm a third-year bioengineering PhD student at the University of Pennsylvania.
My alma mater. Okay, go ahead. I'm a Quaker. Okay.
Or if you want to, they've got a mic right up here.
I don't know if I can really escape to get
Okay.
up there. I'll just speak very loudly.
Okay.
I wanted to ask, how are expert witnesses chosen for cases like this, and to what extent do they have to be or appear to be unbiased as to the outcome of the sentencing?
Okay, Attorney Schiff can talk about it.
That's an excellent question. So I'll distinguish between this kind of case, which is a case of one individual, and the appropriate sentence for this case, where we're not kind of breaking new ground and creating a rule for hundreds of cases, which was the case when we were litigating Mattis. And for a case like this, I would think about the person I want. I do want that credibility of course they're biased, I'm hiring them, I'm paying them, but I want somebody who is not just a hired gun. And one of the things I like about Dr. Kinscherff is he tells me when he thinks I have a terrible argument, and that is true with all the people I use. I don't like to use the people who just tell you whatever you want. So for a case like this, Dr. Kinscherff is perfect because he's a forensic psychologist. He knows the basic law, or the basic science very well. And he's an expert at applying that basic science along with all the testing that he described to individuals and giving the court a kind of profile based in science of who this person was at the time of the offense and their capacity for change. Now with the Mattis case, it was different. Mattis, we wanted the court to be able to understand in detail all of the basic science So when we were preparing for that case, my first step was, as somebody who does not have any kind of significant scientific background, was to learn the science. So I was lucky that I had a law partner at the time who had a PhD in microbiology. So she wasn't a neuroscientist, but she was able to help me kind of like break into the scientific journal articles and start reading them. And I spent many, many hours just reading about the basic science so that I had enough of an understanding to then be able to say, what kind of science do we need for this case? And in that case, what we wanted to do was to show that it wasn't just neuroscience, it wasn't just developmental psychology, it was a convergence of evidence across fields. So we ended up deciding, and I did a little bit of this here, of saying, okay, we want a neuroscientist, and how did I find Adriana Galvan? I actually found her by reading an amicus brief that had been filed, which is a front of the court brief that had been filed on behalf of a bunch of scientists in another case, and going through this list of, 25 scientists and Googling them and seeing what they had done. And she actually had done some, like a TEDx talk or something like that. So I was actually able to hear her talk. She had an amazing CV, amazing credentials, and she was really, really good at describing the science in a way that was comprehensible even to lawyers and judges. So she was perfect. So then we had, in my mind, the most basic of science, which is how does the brain work? How does the brain develop? Next step, we wanted to think about, well, how do they study behavior in the laboratory? So developmental psychology. And this was in a case that was going along with ours. We didn't actually call this witness, but Larry Steinberg from Temple University, who is the guy in developmental, you all probably know better than me, but developmental adolescent psychology. And he is not a neuroscientist, but he studies behavior in the laboratory and how people react to different kind of stimuli, hot, cold cognition, circumstances, that sort of thing. And then we wanted somebody to describe, well, we know this kind of this general stuff from studying the brain, studying behavior in the lab, but how does this play out in the real world? And that's where Dr. Kinscherff came in. As a forensic psychologist, he was able to talk about how this science plays out in individual cases and how studying this stuff in the real world shows that not only is this true when you look at the brain, not only is this true when you look at the way people react to different kind of stimuli in the lab, but it's also true when you look at FBI crime statistics and the way people tend to desist from committing crimes as they mature. So that was kind of a long-winded version, but I think that gives an idea of these two different kinds of cases. Now, when I'm looking for somebody like Dr. Kinscherff, I just ask other lawyers and that kind of stuff.
We're at 2:30, right? So. Okay, all right. 5 more minutes.
Hi. I got in late, so hopefully this question doesn't reflect something I missed. But you were, in the conclusion to this example, it didn't actually sound like the science actually had any impact. The things you were talking about in terms of mitigating circumstances had to do with general views on incarceration rather than anything about this. And also I'm wondering...
I
Okay.
did accept the science in terms of the hot cognition, in terms of, I did accept the science. I should have said that. I did accept the science.
Okay, so that was part of it. And then, so with a case like this, where it's really talking about, and again, correct me if I'm wrong, more about the general nature of adolescence as opposed to a problem with a particular individual. And presumably the law already knows at least something about adolescence and adolescence being a different stage and has already in a way discounted it, and by not treating adolescence differently as a matter of course. How does that use of science differ from, say, other kinds of cases? I mean, in this, it sounds like it's just sort of giving a scientific basis, or if one wanted to be more negative, a scientific patina just sort of a general understanding that might or might not be taken into account because it's adolescence, rather than the science being fundamental like it might be if somebody did have a lesion,
Well,
for
let
example.
me give you an example of how
Yeah,
this
please.
plays out. So, Miller was in 2012, and shortly afterwards, after the Miller case, where this kind of science was before the Supreme Court, there was another case involving adolescents making reproductive health decisions and whether or not they could make sound medical informed consent decisions. And in that case, the American Psychological Association basically talked about some of the stuff I did by about age 16, right? And Scalia was livid because he basically said, I'll keep this short, which adolescent do you want me to see in the courtroom? The impulsive, reckless, feckless, but potentially lethal adolescent whose brain is barely working? Or do you want me to see the contemplative, calm, analytic adolescent? So which science is it? And the answer for really was we didn't have the science yet because of factors in the research sampling, and Francis is here, can probably speak to this more elegantly than I can, but the hole that we hadn't filled yet was that in fact this vulnerability to hot cognition persists, so that although they look very functional under most circumstances, that's why they can be on dean's lists, under certain kinds of circumstances, their thinking is not adult-like, right? So you're right, these are the general characteristics. The challenge then becomes applying it in the individual case, and do we have the science to understanding how it can be the same brain that is a 4.0 physics student, but also having unprotected sex, drinking wildly, and getting into bar fights on spring break.
I know there are more questions, but we're at time. So what we'll do is we'll stick around because many of you have to go to your next session or your flight. I want to do 3 quick things before you leave. 1, if you want to get more involved and more information, Craig, can you raise your hand? This is Craig McFarland, part of our team. Got the laptop? Come up, name, email, and we'll put you on the list where we do this kind of stuff all the time. And it changes year to year. So that's first thing. Second, thank you to AAAS, to Teresa and to Joel. And finally, thank you to all of our amazing panelists. You want to add?
What I also want to add is if you're interested in this particular area, there is a free open access Neurolaw library. Just go to the website for Center for Law, Brain, and Behavior, and you'll see the science side of it. You'll also see examples of briefs and amicus briefs, all kinds of stuff. So Center for Law, Brain, and Behavior.
CLBB.mgh.harvard.edu. Let's thank Dr. Kinscherff, Judge Bernard. Just stick around and talk with anybody who wants to talk.